perspective of the South African Human Rights Commission, this forms part of the Commission's promotion mandate, where we are making people aware of their human rights through our Section 184 mandate. We are mandated through the Commission and the SAHRC Act to promote a culture of human rights, and that means that we have to cover issues that are currently happening in society, and for us in the Gauteng Provincial Office, issues that are pertinent within the province. And though this is an important issue nationwide, but it also finds great importance in Gauteng as the economic hub. Many people rely on domestic worker services for them to be able to do their primary jobs. But when we look at the issues of how the rights and the challenges intersect with perhaps an employer's rights, the challenges with perhaps even the budget cuts through the budget cuts that are currently being implemented by the state, looking at the issues of gender, looking at the issues of the law reform. We have to have, and we constantly need to have these discussions and make sure that these discussions are available for all. It is on that basis that I'll also just put on record that we are recording the service, the discussion. People can join us via Teams, and it will also be available on YouTube should we want to refer back to it. And as we said, the purpose of this is so that there is a record for anybody who ever wants to come back and access this information. It will become readily available to them. So colleagues, introductions, I think we will leave that to Ms. Blouse, who is the facilitator of this discussion today. But on behalf of the SAHRC and the WLC, welcome to everyone. Thank you very much.
Thank you, Zama. Good morning, everyone. My name is Chrissy Blouse. I'll be the facilitator for this morning. Should I speak through the mic? Always, okay. So I'll just hold this here for today. What I want to do, thank you so much, Zama, for the welcome and the introduction. What I just wanted to do first and get it out of the way for the day is just a little bit of logistics, just for everyone in the room. So as Zama mentioned, we are live recording the session. And so that's through Microsoft Teams, and there are colleagues who are joining online, and the event has been shared on different platforms, so it's really open to anyone to register and join online. The recording will live on YouTube after this, and I'm sure we could always make arrangements to also share the links for that. During the day or the morning that we'll be together, there is interpretation. So if everyone can please speak clearly and at a good pace. The bathrooms are right outside this door. If you go out here, there's a bathroom with the sign on the door. And then we're hoping to finish around 12:30 today and then have a light lunch afterwards. Hopefully no later than 1, so everyone can still plan the rest of the day. So that's just logistics and some house rules. There is Wi-Fi access for those who need access to any of their devices, and the code is on the whiteboard in the corner of the room. So as Zama mentioned, we're having a discussion today around the rights of domestic workers, particularly in light of the COIDA amendments that have taken place over the past few years and various litigation, law reform and policies that have been implemented. When we discussed this roundtable and dialogue as the Women's Legal Center and the South African Human Rights Commission, we really looked at it as a space for collaboration and solidarity, in the sense that we cannot talk about domestic worker rights, as Zama mentioned, if we do not look at the various issues and intersecting issues that domestic workers experience and their lived reality, but also if we do not consider the employer's rights, obligations, purpose, as well as the Department of Labor and the Compensation Fund. And we thought it would be really useful to have an interactive discussion with all stakeholders within the space today, so that we're at the beginning of the year. Everyone is in their strategic planning phase for the year. And so that as we look at domestic worker issues and rights throughout the year, those initiatives would really be informed by content that we get from today's session. And so with that being said, what I would like us all to do is to go around the room and have some form of introductions so that everybody knows who is situated in the room today and from which organization we are. And I'll start. I'm from the Women's Legal Center. It's an African feminist law center. We're based in Cape Town, but we have a national footprint, so we work across South Africa. And the Women's Legal Center really uses different tools, such as strategic litigation, advocacy, education, and training. And essentially, we work with 5 thematic areas. So that focuses on women's rights to be free from violence, women's rights to work in just and favorable working conditions, women's rights to sexual and reproductive health rights, women's rights to equality in relationships, and women's rights to access land and housing. And while we have those 5 thematic areas, we understand that women experience discrimination in an intersectional manner. And what that means is that women can experience violence, but you can experience it within your home or within your workplace. So your rights to work will often intersect with other rights, like to be free from violence, or like the right to land and housing, for example. And over the past 4 years, the Women's Legal Center has been actively involved in litigation around domestic workers' rights, including the case of Mahlangu in the Constitutional Court, which other colleagues will also speak to today. And we've been actively involved in making submissions to the Portfolio Committee on the COIDA amendments that have taken place now a year, almost 2 years ago. And so ultimately, the aim of our work is to ensure that litigation, policy, law reform is really informed by the lived reality of domestic workers. And that's why we wanted to have this collaborative discussion today, because we don't want to work from the top down. We want to work from the bottom up, and we want the issues and the lived realities of domestic workers really to inform all of our strategies and the way in which we work. And so that's our organization, that's the way in which we work, and that's specifically the work we do around domestic workers' rights. I'm going to hand, I think, the mic around, I think we all have mics, and I think we can just start on my left, and then what we'll do is go around the room, and for each person, just please introduce yourself, your name, your designation, which organization you're working at, and then the work that your organization does in relation to domestic workers, whatever that may be, and maybe just to also have each of us give an expectation of what would be useful for us to get out of this dialogue for the work we do in our space today, so that we all also are able to frame that type of collaborative action at the end of the day, and it's informed by our expectations and by the needs of our work. So I'll hand over now.
Thank you, Program Director. My name is Herima Pologela. I'm from Compensation Fund. I'm a legal officer there in the legal services. The mandate of Compensation Fund is to compensate for disablement of occupationally injured or deceased employee. This means that we receive claims from employees who are injured or who contract occupational diseases. We paddle them through the adjudication process. We determine their benefits and we pay out their benefits, but there are also internal remedies where you are not happy with the benefits that are paid or the benefits that are denied. Yeah, so we are, and we've got national footprint because we are a national, our legislation is nationwide. It applies to the whole country. I think I will leave it at this stage. Thank you.
Thank you so much.
Morning, colleagues. My name is Vusizwane. I'm from the Legal Department Compensation Fund. We are dealing with the hearings and objections. Remember, if a person is affected by the decision of the commissioner, he has a right to appeal that decision and to be heard by the tribunal. So we listen to we attend to those matters of the objections, the appeal that is made, that is affecting. Remember, the decision, it affects your life. So you have a right to appeal it or get a reason why it was dismissed or claim or what is the issue. Then we entertain to those objections, make arrangements, and make sure that they are heard by the independent tribunal. Thank you so much.
Thank you very much, Facilitator. My name is Rona Bakker. I am the Policy Manager of the National Employers Association of South Africa, NEASA. And our main goal is to represent, support, inform, and fight for the rights of employers in South Africa. We also have a national footprint. We have offices across all of South Africa. We have members, employer members, well over 8,000 across all industries and all sectors in South Africa. I must say I feel extremely privileged that we were invited to participate here today, because I think we're dealing with a different type of employer. What I would like to gain from today is to hear from the various stakeholders, what are their challenges, what are the benefits for domestic workers, what are their circumstances like, and what could they benefit from a relationship with NEASA to ensure that we empower the employers to ensure the safety and the equality of domestic workers in their workplaces. Because I think for a long time, the sector of domestic workers was considered a more informal type of employment or employment situation where people form part of families. It's not over-legislated. It is not over-regulated. But that also causes quite some trouble, because those employers might still look at themselves as employees and not as employers. So it would be very beneficial for NEASA to know where we can play the strongest role to inform and assist the employers to ensure that the rights of domestic workers are respected. So we'll talk about the compliance burdens on employers today. I think NEASA could come in there and explain a lot of the challenges, as well as the challenges that some of the employers are experiencing with the online compensation fund systems. It's great that I have two stakeholders across from me and next to me. We will most definitely exchange numbers after today's roundtable discussion as well. Even though NEASA is fighting for the employer's cause, we all know that when employers comply with the legislation, that is to the benefit of their employees, and that is what we all want in the end. Thank you very much.
Good morning, colleagues, and thank you to the program director. My name is Asenati Tugela, and I come from the Socio-Economic Rights Institute of South Africa, SERI. I work there as an attorney. So our involvement in the Mahlangu matter, I think it's quite clear. We were involved in the litigation, the High Court and the Constitutional Court litigation that I think brings all of us here in this room today. We have been involved with domestic workers even after the Mahlangu judgment in ensuring that at least the gains of the judgment are protected, and ensuring that at least that there is access to COIDA for domestic workers post the Mahlangu judgment. We have been working with a lot of stakeholders, including Domestic Workers Union, to craft advocacy plans on how to advance the gains of Mahlangu judgment. I think that's what brings us here today. Thank you so much.
Good morning, colleagues. I am Kobo Ningiza. I'm also from SERI with my colleagues Anati. I'm a candidate attorney. So I think Nati has said a mouthful. So thank you.
Good morning, colleagues and comrades. My name is Yongeza. I'm also from Seri. At Seri, I'm an advocacy officer. So just adding to what Asenate has said, Seri's involvement in COIDA and in this important case of Mahlangu was through litigation. However, we do know that the victory does not end in court. There's still some work that needs to be done in terms of the advocacy, ensuring that domestic workers know their rights, and also ensuring that systematically the compensation fund and other relevant stakeholders have the system in place to ensure that the domestic workers do actually realize their rights, which are material in a sense. So having been at Seri, I've been working around the event called the annual Mahlangu event. So we had the last one last year in November, which was the third one. My expectation today is to see and discuss ways to ensure that domestic workers do know their rights, and also to see what are the systems or plans by the compensation fund, by the Labour Department, by the relevant stakeholders. So those are my two expectations. Thank you.
Good morning, everyone. My name is Pinky Mashiani, the founder and the president of the United Domestic Workers of South Africa, UDOSA. And I can proudly say that I'm the person that brought you here together, because I'm the person behind Maria Mahlangu. You will never hear a lot about me. It's just like singing Nkosi Sikelel' Africa, not knowing who's the author of the song. I'm the person who found the case of Maria Mahlangu and worked on it. In 2016, that's when I met Seri. I started with the case in 2012. So I'm happy to be here. UDOSA is educating domestic workers about their rights and how to defend them. We have learned along the way that many employers are not comfortable with us to contact them and say, Maria is saying this and that. They prefer the domestic workers to speak for themselves. And it's unfortunate that many domestic workers are afraid to approach their employers. So as UDOSA, we are trying to make that relationship, how to approach their employers, how to know when the employer is happy to approach her today and make a cup of tea to ask for an increase. What I'm looking at today is to find ways of making this COIDA to work for domestic workers and to educate more domestic workers and employers about COIDA, because I'm definitely sure that there are employers who don't know about COIDA. There are many domestic workers who don't know about COIDA. So if we can come together and find a way of reaching out to those people and educate them about COIDA. I have found some organization, powerful organization, holding meetings and speaking to themselves, not including domestic workers. We are not moving forward if you exclude domestic workers where matters are concerning them. Use your resources to educate domestic workers and employers about COIDA. Because one thing for sure, what is my dream is to see a healthy working condition between domestic workers and employers. Finding a domestic worker working, singing a song or a hymn to show that she's happy at work. Thank you.
Good morning, everyone. My name is Maggie Mtombeni from the organization called Izwi Domestic Workers Alliance. I'm one of the co-founders. So Izwi Domestic Workers Alliance is where we are educating domestic workers about their rights, also about their duties as responsibility, also as workers. And then we are also trying by all means to reach some employers and educate them to comply. And then my expectation today is to hear about the employers' organization, that are they educating their clients about labor laws or also about the COIDA thing, because most of domestic workers, they're still not registered under UIF. So my question is, are they still going to comply to register them under COIDA if they still can't register them for UIF? Thank you.
Thank you so much to everyone in the room for the introductions. I'm very excited by all of us in the room, but I do just want to be mindful that we are doing a live recording of the event and that there are a few participants online. And then we have someone in the corner also who just needs to introduce herself. Andile, I don't know if you have a mic there. Thank you so much. And then in terms of just giving everyone online an opportunity to introduce themselves, we're not able to. Okay. So what I can ask is that I can see there are about a few participants online. Thank you so much for joining us. Can I ask for you to please maybe put in the chat box your name, which organization you're from, and then how your organization works in relation to domestic workers, just so that we capture for our discussion today who attended online, but most importantly, the work that you do or what you would like to see in relation to domestic workers. And then maybe just to say that if you have any questions, input, want to know anything, please do put it in the chat box, and then we'll often check throughout the session as the session goes to ensure that we are covering everything that's reflected online as well. We're so grateful for your online attendance. Okay, so now that we know who is in the room, I'm quite excited because when we introduced ourselves, it was such a nice overview of legal, advocacy, policy, and domestic workers. And I think that that's so important because it shows the importance of working through a multi-pronged approach. We cannot do law alone because the law only takes us that far. We cannot do advocacy by itself because it only takes us that far. And so we need to have this multi-pronged approach if we really want to achieve true substantive equality for domestic workers and their rights. And so what I want to do before we go into specific questions for participants in the room today is just to set the scene. And I believe that setting the scene is really essential when we're going to have fruitful discussions because everything happens within a particular context. And it's important for us to have the context in the room today because we are from different organizations, we're from different positionalities. And what happens is that often when I come from the Women's Legal Center, I come with my perspective. When you come from the Employees Association, you come with the employer's perspective. But I think to just ground us within our discussion today, I just want to set the historical context for us around domestic workers and the domestic work sector so that when we go through our discussions today, our responses are informed by that context. And we have a very particular historical context in South Africa, one that is deeply rooted in segregation, in apartheid, in colonialism. And we cannot move away from that context without realizing women's roles within the workplace historically. Historically, women's work was always deemed to be undervalued and underpaid. More specifically, for years, the exclusion of domestic workers from COIDA specifically discriminated against black women in South Africa. And we need to be mindful of that because we cannot speak about a particular sector as if it is all women. We need to have the intersectional lens that looks at people's discrimination based on their race, based on their class, based on their socioeconomic background, based on their nationality. Because we also know that many domestic workers who struggle in relation to access to documents within South Africa have a compounded vulnerability in accessing employment rights. And so in South Africa, we have a vast array of human rights in relation to the employment sector, and our labor relations, our labor laws essentially are quite, we have a big umbrella of labor laws. And And those all feed through the constitutional rights that are contained in our Bill of Rights within our Constitution, which is the supreme law of South Africa, like the rights to equality, dignity within the workplace, the rights to be free from violence within the workplace, the rights to social security. However, for domestic workers, up until the Mahlangu judgment, they were not able to access those rights because of their specific exclusion from COIDA. And it's a specific exclusion from COIDA because there is no rational link to removing domestic workers from compensation and not recognizing their rights within the home. And why that context is important is because it shows us we had this historical context, but that history actually came into our laws. And for years, our laws actively perpetuated that narrative. Because our laws, even though it's founded on this constitutional and human rights principles, specifically excluded domestic workers. And for years, that exclusion was unjustified until the Mahlangu judgment recognized it otherwise. And it's important to realize that our rights within our Constitution, is underpitted with values from international principles through CEDAW, international conventions, general recommendations on the right to work, the ILO Convention 189 on domestic workers. There's now the ILO 190, which speaks to violence, harassment in the world of work. So there are all of these beautiful international principles in relation to the right to work in safe and just conditions. And then we have our human rights principles within our Constitution. And we know that, rights are interdependent. You can't have the one right without the other. They need to work together to give true protection and substantive equality. And that is the context we sit within today, in understanding that, like you said, we have all of these labor laws. Domestic workers still work within a sector that may be regulated to an extent, but there is a complete lack of oversight. Because when I step into someone's private home, there is no oversight of what happens within that home place. And that compounds my vulnerability as a domestic worker, because we then start to sit with competing rights of right to property, my right to privacy, versus someone's right to their employment and their labor rights. The other reality is that we have to be mindful that when we speak about the domestic work sector, we cannot speak about labor laws in general, because where, for example, if I experience sexual harassment within my workplace, if it's an organization, there may be an HR person I can complain to, and there may be a process that I do that confidentially, and I can lodge that complaint. If I'm a domestic worker working in a private home, there's no way of me doing that complaint confidentially. And so we sit with this impact. And Usa Pinky was saying about education and awareness on the lived reality of domestic workers. We sit with a discord between law on paper versus how law is implemented in reality. And that's the discord we want to bring closer for domestic workers, in that the law that's on the paper and in the Constitution is not so far removed for domestic workers, that the law becomes closer and becomes more real, and that there's more real protection for domestic workers. And that's the scene we want to set for our discussion today, so that we all kind of come to a collaborative understanding of this context that's informed by the lived reality of domestic workers, and that informs initiatives from that space. And to start with that, I thought it would be really nice, as Pinky, like you said, you worked on the Mahlangu case, I think, since 2012. And really all of us have interacted with you in different phases over the past now 10 years around these issues. And I think what would be so nice for us to start the day on is the context of Mahlangu, if you can bring that closer to us and just give us an overview of what brought us to the litigation. Before we hand over maybe to our SERI colleagues to tell us what is the current legal position since the judgment. So we have the understanding of what brought us here and where are we today in terms of the law.
Okay. When I started with the case of Maria Mahlangu, I wasn't familiar that much with many laws, but one thing for sure that I knew is that domestic workers were discriminated. That's why the first place I went to Equality Court, because I felt that there was discrimination against the domestic workers. I went to Equality Court to open a case against the minister and against the employer. So I was sent up and down. I went to UNISA, I went to University of Pretoria. Doors were shut. It was shut before my face when I was seeking for help. As we all know, that domestic workers was not formalized, as Chrisky was saying. When I heard about Mahlangu story, it was not the first story that I heard about domestic workers dying on duty without anyone taking responsibility, neither the employer nor the government. It was maybe the third or the fourth domestic worker that died on duty, and it was just a story, a short article in the Pretoria newspaper with no one will follow it. I knew that nobody will do anything about it. That's why I started to seek justice for Mahlangu. I called her family, I found them, and then I started to go with her daughter, Sylvia Mahlangu. The first place was UIF, and I knew that she was not going to get it because she was over age, and she never got it. Obviously, I knew that domestic workers were not covered by COIDA, and I told her about that. Then we started to seek justice. We went to Wits University until we reached SERI in 2016. So domestic workers have been faced by those injustices of the past, that when they were injured on duty, nobody took responsibility. I had cases where a gardener was asked to clean the windows there in Pretoria, Mayor's Park. He fell, and they said he told the employer that the step ladder was not stable. And the employer said to him, he was trying to ask him to hold that step ladder, but he said, no, you are not going to fall. And he fell from that second floor house. He broke his upper leg. He's crippled as we speak, David Ngobeni. And the employer called his brother to fetch him. They used a bike. They took Ngobeni to Dacha Hospital in Mamelodi. And the brother said they found him lying next to the road. He told me that I was in pain, but I could hear what he was saying. He told the nursing staff there that he found me on the side of a road, injured. So those were the injustices that I was looking at, and I said, somebody has to do something. The government must take responsibility. Domestic workers are workers like all other workers, and they have rights like all human. So that's why I seek justice for Maria Mahlangu and for domestic workers as a whole, because I even told her daughter that this is not only about your mother. I want you to know that this is about all domestic workers in South Africa.
Thank you, Ms. Pinky. I wonder if it would be a good point to ask our colleagues from SERI what kind of legal interventions took place in Mahlangu and what informed those legal interventions, and more specifically, just to set the scene in terms of, since the judgment, what is the law in relation to domestic workers? Like Sis Pinky explained, there's a story of a domestic worker who fell within their workplace, who was unable to access UIF or COIDA. What is the law since Mahlangu, and how is it supposed to effect protection for domestic workers?
Thank you, Program Director. I think let me start by stating a few realities about the sector of labor called domestic work, and then perhaps set out a background of the litigation. The first sad reality is that none of us would be gathered here today, and COIDA would have never given any recognition or attention to domestic workers if a domestic worker didn't fall into a swimming pool and die. And that's the reality that we must first understand and appreciate, so that we understand that when it comes to domestic work, there is always an attitude of not recognizing them as workers and as a group of human beings within our population that contribute to the larger labor market. So the Mahlangu judgment, quite interestingly, it came, I think, and I always argue that it came at the right time, as sad as the facts were, because the gain that came out of the judgment or out of the case was that at least now there is not only recognition of domestic workers as employees or as workers, but there is also the attention that the domestic worker sector has been given as a result of the judgment. So in relation to the Mahlangu case, Ms. Mahlangu was employed as a domestic worker at a private household in Pretoria, a place that she had worked at for more than 20 years at the time of her death. On 31 March 2012, while carrying out her duties, a similar scenario to what Sisping is telling us about, where you are simply forced to do work that you do not think that you are physically capable to do, and work that you do not think that you will be safe and secured in doing that work. So she was instructed to clean the windows of the house on the outside, just near a swimming pool. And I must state that while she was doing this work, the swimming pool, which wasn't far from the vicinity of the windows, was uncovered. She slipped and fell in the swimming pool, and because she wasn't able to swim, she drowned and died. Her employer found her lifeless body in the swimming pool, and that was the beginning of what brings us here today. So Sylvia was the daughter of Ms. Mahlangu, now working with the activists in the domestic worker sector and labor unions, specifically SATSAU, began a very lengthy and tiring process where they were trying to seek justice for Ms. Mahlangu. But what came to the fore for them was that the legal jurisprudence as it was at the time did not recognize domestic work as work. And this is because Section 1 of the COIDA Act, of COIDA, specifically excluded domestic workers expressly from the recognition of organized work, organized labor. And effectively, this meant that Ms. Mahlangu would also be excluded from the protections and the gains of COIDA. In fighting against this injustice, SERI, the trade union, and the Mahlangu family instituted proceedings at the High Court in May 2019, requesting that the court must look into the injustice that occurs as a result of COIDA not recognizing domestic workers as workers. Particularly the fact that the consequence of this lack of recognition means that the domestic workers' right to social security was not being recognized. When you perform work that you are being paid for, you are doing so in exercise of your right to social security, which means that if an incident occurs that forces you to no longer perform your duties as an employee, there must be an intervention that seeks to compensate your now lack of ability to provide social security for yourself and for your family. Similarly, in this matter, Ms. Mahlangu was the breadwinner of her household. And because she had died in the circumstances that she died, and there were no protections for the social security that she was providing for herself and her family, and that COIDA was also failing to close that gap, we thought that this is a violation of the constitutional rights that Ms. Mahlangu ought to enjoy. So we launched litigation at the High Court to declare Section 1 of the COIDA Act unconstitutional to the extent that it does not recognize domestic workers as workers. We were successful at the High Court, And because this is an order that speaks to the validity or the constitutionality of a piece of legislation, we had to bring that to the Constitutional Court for confirmation. The Constitutional Court recognized our request and granted the confirmation application. So now the effect of this is that when a piece of legislation or part of it is declared unconstitutional, the effect of the application of that legislation or piece of law now changes entirely. In respect of COIDA, the very significant declaration of the Constitutional Court was that Section 1 is now unconstitutional to the extent that it doesn't recognize domestic workers as workers. And effectively, the legislature had to amend that section to ensure that it provides inclusion to domestic workers. But importantly, the Constitutional Court not only declared it unconstitutional, but recognized that this was a limitation and violation to constitutional rights that all of us began to enjoy as early as 27 April 1994. And in doing so, they understood and they recognized the fact that not only is Ms. Mahlangu affected by this judgment or by this violation, but it also means that thousands and thousands of domestic workers have been excluded from the fund. And thousands of domestic workers who have been injured or died during the course of their employment or contracted diseases during the course of their employment have found no recourse because COIDA refused to recognize them as workers. So effectively, the Constitutional Court said, if we ought to declare this section unconstitutional because it doesn't recognize domestic workers as workers, then we ought to take it back and apply this retrospectively. I must highlight that there was a lot of objections to this idea of retrospectivity, simply because there was a thinking that if we do take it back as far as 1994, we are going to see an influx of claims or an influx of domestic workers coming to the fore to report that perhaps maybe in 1998 a certain event occurred to me. But I'll let the entire room discuss on that, because since the Mahlangu judgment, we have only seen about 7 claims in relation to domestic work. I cannot account for how many new registrations of employers we've seen as a result of the judgment. But these are the things that I wish that we can discuss to see if the Mahlangu judgment has shown any significant gains and whether the legacy of the judgment is reaching the endpoints that we want. But I must highlight that arising from the Mahlangu litigation, one of the most obvious problems that were displayed by the litigation was that we have a history of not recognizing domestic workers as workers. Whether it's ourselves as members of society, or it's government administration, or it's the law as it is. But there is a long history of not recognizing domestic workers, not only as employees or as workers, but as people who are deserving of the protections of the Constitution, and as people who are deserving of the protections that labor law and labor jurisprudence in the country displays. And it was clear from the Mahlangu litigation that if there is certain categories of workers that are recognized and protected under COIDA, simply for being workers, and simply because we recognize the work that they do and the contribution of the work that they do, it then boggles my mind why the same principle cannot be applied to domestic workers. And it leaves a lot of room to wonder as to whether we fail to recognize them because we fail to recognize the work that they do and the contribution of the work that they do. I often say when I have to speak about COIDA that the way that domestic workers are so important to us, to the society. Basically, they are so important that everyone in this room has had an interaction with domestic work. Whether you hire a domestic worker at home, or you grew up in a household that had a domestic worker, or you grew up in a household where either your parent or a relative was a domestic worker, it is almost the same as mine work for black people. It's a component of our identity that we should always recognize and protect. So the Mahlangu judgment brings us to this conversation. It brings us to the conversation of recognizing domestic workers as work, but also an extensive conversation of, now that we have the gains of the Mahlangu judgment, how do we expand on those? How do we protect those gains? How do we ensure that there's sufficient advocacy for everyone outside of this room and outside of the interest of domestic workers, for everyone to be aware that there is available protections for domestic workers? I do hope that I've answered your question, Program Director, and thank you.
Thank you very much for that oversight, and particularly for going through kind of the litigation and the significant gains that we've made. I think the part you ended off with, I think, is the most important part, and it's this question about, we've made significant gains, but how do we protect those gains and ensure effective and sufficient advocacy around those gains? And I think that's where we go to the department and ask just now, as we're still setting the scene and the context, in light of the gains that were made through the litigation, and domestic workers is now recognized and has protection in terms of COIDA, what does that look like in terms of a department process? Can you just give us the initial overview of what that process should look like for domestic workers? But more specifically, because I think this goes back to ensuring that even our laws are informed by the lived reality of domestic workers. Because what are the types of complaints that we consider as viable for domestic workers to come to the compensation fund? So maybe let's do it in a three-part question, if I may. One, what is that process at the department? So for any domestic worker who wanted to come and lodge a complaint, or for a family member who wanted to come and lodge a complaint, what is that process? But then secondly, what are the types of complaints that domestic workers can come and make? Because I think during the introductions, there was a lot of indication around how domestic workers need the education and awareness around the complaints and complaints process. Because if for 23 years I was not included in COIDA, I now am, and our colleague says how there's now retrospective effect. For the domestic worker working, whether it's in a rural area or in an urban area, I may not be aware of the law that has changed. But first of all, I may not even know that what is the thing I claim for. Do I only claim when I fall off the ladder? Do I claim when there's violence that takes place in my workplace and I'm injured because the home is where I work and I'm abused by my employer and I sustain injuries? That's arising in and out of the scope of my employment, right? Because if we look at the definition in terms of COIDA and its protection, it's for any injury, occupational disease that arises in and out of the scope of my employment. And so I think it's easier for us to understand. Sorry, is it my mic? I think it's I think it's easier for us to understand that if we use another, I don't know what other work example we can use now where it's clear, this is kind of the outlines of the work. But where I work in a private home and the duties differ between domestic workers, what constitutes that injury in and out of the workplace for me who works in a private home, and what does that process look like for me to come and make a complaint, and the kind of criteria, so that we have that basic understanding of what that process should look like.
Thank you, Program Director. The claim process for all employees, including domestic employees, is the same. We actually call them employees and not workers. That's what the Act says, is the same. And it starts with the employer having to report the accident or occupational injury, occupational disease. The employer is expected to report in terms of Section 39 any accident within 7 days of the accident. Or if it is not reported, actually the employee himself or herself, he has got 7 days also to report to the employer that I was involved in an accident, and the employer has got 7 days to report it to the Compensation Commissioner. What must accompany that report is the employer's report of accident, in which he gives the details of how the accident happened, and then if there are any witnesses to that thing. And he must include also in the employer's report the salary that the employee was earning at the time of the accident, because we use that salary to calculate the benefits that are payable to the employee, the injured employee or the deceased employee. And what also must accompany the claim is the first medical report, because it's all about injuries. Without the medical reports, then we will not be in a position to adjudicate the claim. So there must be the first medical report, and there may be also progress medical reports until the final medical report is issued. Once the final medical report is issued, then the process of adjudication starts, where now the claim is going to be adjudicated upon. And then in the process of adjudication, we determine whether the liability is acceptable or not. And then also the extent of disablement. And then the benefits are payable according to disablement. For an example, if you are injured or you are diseased, what we pay is the medical benefits, but we also pay your salary during the period of absence of 4 days or more than 4 days. We also pay this permanent disablement of 1% to 100%. 1 to 30 is lump sum, and then from 31 to 100 is a monthly pension. We also pay the widow and child pension where the employee gets deceased as a result of the injury or occupational injury, occupational disease. We also pay a constant attendance allowance. We pay funeral costs. We also pay for the costs of rehabilitation of the injured or deceased employee. So the process is the same for all employees. The domestic employees do not constitute a particular class of employees. They are just treated the same. But where the employer does not report, there is a duty on the employee also to approach compensation fund and to report. We understand the challenge. The challenge will be that he would not have the employer's report. And then without the employer's report, it's difficult to register a claim. So there has not really been much breakthrough since the case of Mahlangu. I don't think we have got more than 30 cases reported. I don't have the precise stats, but the last time I checked, it was around 20. So despite the judgment and despite the fact that we have also amended our legislation to align it with the judgment, there is not much breakthrough, because these people are working in private households and they are vulnerable. So they did not want to go against their employers to report their injuries or their diseases. I think that's the process of the overview of the process, the claims process of the claims. I'm sure my colleague can add.
Yes, in the case, as you mentioned, when the claim it has been adjudicated, then we make a decision. Should the employer not be satisfied with the decision of the commissioner, he has a right to appeal that decision. If I've mentioned that Section 91, they are also covered on that section that they can appeal the decision of the commissioner via an objection. There's an objection form that must be submitted within 180 days. So at the moment, if the employer failed to report the matter within 7 days, the employee has the whole year. Before our prescription at the moment, it is 1 year that he must come and approach himself personally and give reasons. And that matter will be treated as a non-compliance. It means we will investigate why the employer did not comply with the Section 39, that he should have reported the matter within 7 days. And the Section 39 in our Principal Act says that the employer will be found guilty. So I'm happy that the representative of the employer is here today, that they will be found guilty before the amended one that you said they would be hit with a penalty. But at the moment, they are found guilty of the violation of that act. And you also mentioned the issue of what kind of the complaints do we receive. One of them is the non-compliance. Some of the employers, they don't complain. They don't report the matter to the fund on time. So those one will be treated as non-compliance. But the process is the same as any other employee, and also it will be adjudicated and it will be fairly communicated with the employee. What is the outcome and what document they need to be submitted. Thank you.
Thank you very much. There's several questions that comes up automatically for me in my head, but I'm going to stick to my program facilitation and not go to the questions, because I do want to give other colleagues an opportunity to maybe the questions come from them. But I wanted to ask just one point of clarity. When you said in terms of statistics there's maybe only 20 claims, is that nationally or only for the province in terms of those claims?
It is nationally. Thank you.
You gave us 3 categories of the questions. Are you done with the processes, or should I proceed with the other 2?
Can you keep the other 2 for me for later?
Thank you.
Because I do want to, at this point, give the Employers Association an opportunity to reflect on the laws and the processes. And then I want to give ISWI maybe an opportunity to also then reflect on access for domestic workers in terms of the process that was outlined afterwards. And then Sispinki can add. Because we spoke about the judgment and the significant gains made in the judgment. We know that the judgment and the decision of exclusion being unjustifiable directly resulted in then the policy and the law reform and the COIDA amendments that then took place. And then now thank you so much for outlining to us what the process is, the categorization of complaints and injuries. And then I think the thing that we pick up most importantly from this process is that ultimately it's the employer's obligation to lodge the complaint. And so maybe we can give you an opportunity now to speak from the Employers Association about your interaction with that process. Maybe we can just even say if employers generally are aware of the Mahlangu judgment and the COIDA amendments, and if they are they aware of the obligation to lodge the complaints, and what your experience has been in terms of complaints and the process interaction.
Thank you very much, Facilitator, for that, for the opportunity to comment on those remarks made. Is this microphone fine? Are you experiencing trouble with it, or would you prefer me to use another one? Thank you, sir. All right. I think what is very important before we address the awareness of employers regarding the change in the COIDA Act is to realize that you get different types of employers. When you look at a company in an industry, you're talking about an employer with a main aim of turning a profit, rendering a service, manufacturing a product, and so forth. And when you look at the employer employing a domestic worker, that is a workplace that hits far closer to home. That is a lot more personal, like our program facilitator said. it is not necessarily over-legislated or regulated at this moment. I know that a lot of domestic workers and employers in this sector don't even have an employment contract. Sometimes it is verbal, sometimes it's not permanent, might be 1 day a week. And all of that, we need to bear in mind this employment environment. And then we have to allocate where do the responsibilities lie of education of the employee and employer regarding their rights and their responsibilities and their obligations. And we have to look to how can they work together to ensure the safety and the mitigation of the risk to the employer for not becoming non-compliant with a piece of legislation. And there's always a certain risk of an employer taking on an employee, whether that's a domestic worker or not. There's always a risk with the employer as well. Because he has to pay this person, he or she has to pay this person. They have to ensure that this person is safe. And once again, in the domestic sector, they have to, yes, adhere to certain legislation such as COIDA, UIF, the national minimum wage. But for instance, if you look at things that go hand in hand with COIDA, you look at the Occupational Health and Safety Act. But who at their personal homes have a policy in place or a document drafted or a set of rules against a wall that says workers must not do this, please do not do that to the outlet, please watch out for the following, watch your step, wear this protective gear. So we have to understand that this employment environment is different. And from the employer's representative side, yes, the moment the Act was amended, we did inform employers. We are well aware that the majority of employers that employ domestic workers might not be business owners in that sense, but they still subscribe to NIASA's newsletters, to NIASA's sector and industry updates, because they are employed elsewhere. They are employees or employers in other sectors, not just with reference to their domestic workers. We aim to educate and inform that they have to comply with the legislation in terms of registration with the compensation fund and the submission of the ROEs, the return on earnings, and so forth. With the reporting, NIASA has a specialist service provider that assists employers with all compensation fund related matters, from the initial registration to the submission of claims, ensuring that they are classified correctly, and so forth. So NIASA will never abscond this responsibility purely because this workplace is different or this type of employer is different. I and Ms. Pinky have worked together before regarding the issues we've experienced with the compensation fund, and we're talking specifically systematic issues with the CompEasy system and claims. The problem is the moment that compliance burdens upon an employer become so excessive that they can't cope with the system itself or financially with the burden of compliance, they tend to become uncompliant or non-compliant. And a lot of people, whether employees or employers, whether it's tax or COIDA or UIF, they fly under the radar. And I think the fact that they feel overwhelmed with struggling with a system that doesn't always work, or with the fact that, remember, we're talking about legislation. Employers aren't legal minds, all of them. They aren't lawyers. So they need our help and our assistance. And it's fantastic to see that all these stakeholders have at heart and in mind to inform, because the moment you inform and educate, they are empowered. You don't necessarily have to take the whole responsibility of ensuring that your constituency is compliant. You ensure that they take that upon themselves. I have to ask the stakeholders here today. We want to ensure compliance by the employer, and we want to ensure the safety of the employees in the domestic worker sector. But to what extent and how formalized do we want this sector to become? We need to ask ourselves that. Because if we look at the sector now, and you see that it is a close to home, very personal relationship between the employer and employee. There's no intermediary HR person or necessarily a contract that can be referred to or a policy that needs to be acted within the parameters of. We need to understand that we need to protect the relationship between the domestic worker employer and the domestic worker employee. We need to protect that. It has a rich history. It has grown a lot. It has made gains through legislation to ensure that the most basic human rights of those employees are protected. And we as employers and employer representatives want that to be sustained. That is very important for us. I undertake as the policy manager of NIASA to ensure that a focus is placed on the knowledge and information that needs to be given by NIASA to employers of domestic workers, to ensure that they understand I am an employer. I might not be a registered company. I might not have a registration number or a formal contract or this policy and that policy, but I am employing an employee. So there are certain obligations upon me, and I also have certain rights as an employer. We have to always, as employer representatives, ensure that all stakeholders are aware of the fact that employers fear abuse of legislation by employees. They do. They do. When there is the opportunity for abuse, it needs to be managed very well, and that is done through proper education of the employee and the employer of their rights and responsibilities. I think as a joint campaign like this started, we can have amazing gains, and we can make sure with the assistance of the compensation fund that the gains made by Seri and by Ms. Pinky and all the organizations, that those rights that have been created through that court case and the amended legislation is carried forward and formalized. Apart from that, we have to understand that if this sector becomes over-formalized, I do fear that employers in the sector might shy away from further employment of domestic workers. If we look at the surveys that NIASA has done in the past regarding compliance legislation, for instance, the national minimum wage being raised to a certain point, that employers decided not to further employ, to lessen the working hours. And that's not something that we encourage at all. I mean, we all know what South Africa's unemployment statistics are. But we have to look at the realities of the compliance burdens upon employers. Now, registering with the compensation fund and then submitting the ROEs and ensuring that you are compliant with that legislation in itself, in theory, is not such a great problem. Employers of domestic workers can be assisted to perform that to ensure. However, we have in the past experienced quite some trouble with the registration and with the claiming with the compensation fund. NIASA has a strong relationship with the compensation fund and their acting commissioner. We're working together on a field of issues that employers are experiencing. I believe if those problems can be solved and we can ease this administrative burden of compliance, it should no longer be a problem. It should no longer be a problem. And if that relationship between employers and employees in the domestic sector is protected and everyone is informed of their rights and obligations, then the freedom to speak to your employer about their obligation to register with the compensation fund should be an easier matter. I truly hope that creates some perspective from the employer side, the risk that they sometimes face, the compliance burdens that they face, but that it is not out of pure not caring that they are not being compliant. I think as we continue with the education of employers and the assistance of employers, there can be great changes for the positive. Thank you very much.
Thank you so much. I think you've highlighted quite a few important points. One importantly about the essence of collaboration and working together and what success that can bring. But also I think something that relates strongly to the context that we've all been speaking about and how specific the sector is. It's not like many of the other work sectors that are very formalized, and you raise an important question about, do we want it to be more formalized? Because there are also consequences that come with that because of this unique nature. And I want to hand over to, I think, Izwi to give us a reflection now on, because we've had conversations now on, from the Mahlangu judgment, this is the significant gains that we made in court and in policy reform. And then we've heard from the compensation fund about this is the process, and domestic workers technically, fit within all of these categories. There isn't a specific protection for them. They should be able to claim in terms of this process. And then from the Employers Association about how employers, essentially there's a difference between employers in terms of the unique relationship that these employers have within their homes, but also the financial burden on individualized employers within their homes and their obligations, and sometimes their struggles to access the system and to lodge those complaints. But I think what would be a good reflection from Izwi is, from the domestic workers' perspective, what has been, because we've heard that there's only 20 claims nationally. What is that reflection from Izwi, from the domestic workers themselves? What is the reflection on the compensation process, and what is the lived reality of domestic workers even now, 3 years? If we look at this year, we're going to say, 3 to 4 years after Mahlangu, where are we still for the lived reality of domestic workers in terms of what you find, particularly within the province where we are situated, but also throughout the work? And I think, Sis Pinky, you can also come in after that in terms of your experience of the lived reality in relation to the law, to the compensation process.
Okay, ngiyabonga isikhathi. I-challenge ekhona kuma domestic workers to claim COIDA. Oh, I'm sorry, I have to use English. Okay, yeah. Sorry? Okay, yeah, the challenge is, what in Kulum? Okay. Yes, the challenge esinayo manje is because of our employers' doctors. Abasebenzi abanengi bathi mabelimele emsebenzini bathathwe ngama-employers kumadokotela abo. And then manje I think isalela muva kakhulu ku-Department of Labour to educate ama-domestic workers employers about ukuthi i-COIDA isebenza kanjani. Ngoba manje ama-employers amaningi ayala ukuveza lobu bufakazi obokuthi umsebenzi ulimalele emsebenzini because i-treatment uyithole kudokotela wakhe, i-employer. And then the other thing is still not clear for us, for ama-migrant domestic workers, ukuthi what they're supposed to have, what they're supposed to put on the table at the Department of Labour so that they can claim COIDA. And then the other thing is medical report. Most of domestic workers, they don't have those medical report. Like since from 1994, even if we're trying to tell them to bring those medical reports as they've been injured at work, they don't have that medical report. And then the other thing is, our employers, most of them, they're unreachable. We can't reach those employers, as you can't claim as a domestic worker without any employer's approval. So i-challenge ekhona sisadinga kancane amakhesi siwathumela eSeri, kodwa since siwathumela eSeri asikabi na i-domestic worker eyi-1 ise-iclaimile because of zonke lezo zinto ezifunekayo ezifanele zitholakale ukwenzela ukuthi aclaime i-COIDA.
I only caught some of this, but I think what I did here is that part of the challenges is that most employers are not familiar with COIDA and what it actually entails. And so because of that, it becomes a challenge that that domestic workers are not registered, right? So that's the first one. Okay. Oh, okay. Thank you. So some of the domestic workers use their employers' doctors. So in cases where they need to then claim, the employers often do not want to give them the information or provide them with the information that they need in order for them to claim.
Okay, in additional, I think the other thing is from the Department of Labor for enforcement to those employers, because like example, we do have traffic register. And then they do have those enforcement of traffic hopper. They are always on the street enforcing drivers to follow the rules. But on the domestic workers sector, we don't have that enforcement to push those domestic workers employers to comply according to the law. Thank you.
Yes, I will add on what Emeka was saying. It is true that we have a challenge with the retrospectivity of COIDA. Many employers have relocated, others have passed away. And the Department of Labor is making it difficult for domestic workers to claim because they say employers must be, policyholders, they must fill the forms. I just want to make an example. A domestic worker was killed on duty, actually with the employer. They were shot at, the employer survived and is not a South African. He was in ICU. From there, when he was discharged, he left the country. So the story was on newspapers, I even have it. So what I'm saying to Department of Labor, that in such cases where there is a story that they've seen or they've heard about, or there's evidence that the family can bring forward that this is what happened, the employer was not a South African and they were both shot at, the domestic worker lost their life. So Department of Labor, are they still going to be difficult and say to domestic workers, the employer who has left the country must complete the forms for you to claim? So another issue, yes, the issue of employers who are taking domestic workers to their own doctors. I have a case of Mhlengeni Hlachwayo. The employer took Mhlengeni to his own doctor. He fell while cutting a tree and broke his wrist. So what happened is that the final medical report says the hand is okay, the hand is right. And there's a plate and there are screws in that hand. And it can't be all right. That head can't be all right because there are objects that are in that hand. There's a plate and the screws. Advocate Chris Msibi from the Department of Labor, I was with Mhlengeni Hlachwayo when we approached the Department of Labor in Pretoria. Sent Mhlengeni, the worker, back to the doctor. Said, you must go to the doctor because you say, even your x-ray are saying that you've got screws and plates, but the doctor is saying that your hand is okay. The Department of Labor will not compensate based on the final medical report by the doctor. So to be honest, there will be employers who are like that, who will make sure that they take domestic workers to their own doctors, and the doctors will write the report that will favor the employers as their clients or whatever. And then it's also a very difficult thing for employers to accept or to take responsibility if domestic workers are injured on duty. I'm saying this, they declared who Mahlangu worked for them. They were refusing to complete the forms for the Labor Department. Until Advocate Msibi, the same Chris Msibi, prepared the papers to take them to court. He was summoning them to court. Then they completed those forms. So you see that it's still going to be a lot of challenges. So that's why we have to work together as NIASA, as the Department of Labor, and us as unions to educate employers, and also for employers to know that they will not be personally held liable if the domestic worker happens to die on duty because others were stabbed. There's one who was stabbed in Vonnerbom in the house while she was cleaning and died. And also we went to look for those employers. Unfortunately, we can't find them. And the son has got all the documents that his mother was stabbed or at work in the kitchen, all those things. Another case I want to make an example about is a case of Selina Dipuoko Kolosi. A domestic worker was beaten by 3 pit bulls at work in Potchefstroom. The employers are defending anything and everything because they don't want to take responsibility. And that's the attitude that we are going to get from other employers. We must not sit here and lie to ourselves and say all employers are going to accept this and say this is good. There are employers who don't want to see domestic workers as workers or as people with human rights. They think domestic workers are slaves and they don't deserve to be protected by any laws. They can do as they please in their own properties. That's what you even heard from other employers. I had an employer, a magistrate that I took to CCMA. He said to me that was not a government, his property is not a government, whatever, that was his property. And I took him to CCMA. He was so embarrassed. And then he said to CCMA, you know, if this lady explained to me nicely, we wouldn't be here. Because he said, I cannot just call and tell him how to run his house. And I asked him that which clause is he using in his property as a magistrate? Which clause is he using? Because there are laws that are protecting domestic workers in this country. So there's a lot that we need to do together. And we can make this work for domestic workers. Yes, we won't get 100% with the employers, but we can make a difference. And some employers will really comply and make this work for domestic workers. Because one thing for sure, domestic work is one work that will always be there. We'll always have employers who are business people who don't have time to clean their houses, who don't have time to do the washing, who wants people to look after their children. And all those people are domestic workers. And it's one work that will always be here. Thank you.
Thank you very much for your overview of what the lived reality and impact is. I think it actually raises 2 very different questions. And it also links to a comment that was made online. If I can just read for everyone the comment that was made online by Kelly Ann Clufas, where she says that most employers of domestic workers will not be registered with a compensation fund. What happens in a case where the domestic worker gets injured on duty? How does the contributions by the employer go to the fund? So her question brings me to 2 points that I think was discussed in the room that's being highlighted. And I wonder if we can split these questions between our legal colleagues from SERI and the fund, because I think the 2 questions that stand out for me through many of the submissions or the overviews that was given today. So we had the law, we had the process at COIDA, we had what employers are doing in terms of the Association for Awareness and Education. Now the lived reality and questions are coming to say, okay, you said if, for example, employer doesn't register or does that, there's the non-compliance clause. And essentially people are asking, what's that non-compliance look like in terms of accountability? Because we hear employers are, for example, using their own doctors, not giving the correct forms. So the way you describe non-compliance is very specific in terms of that section, as in when the employer doesn't report within the 7 days, the employee has a year after to report, and then that's the non-compliance. But I think a lot of the lived reality is showing non-compliance in other ways. For example, this process. So there's the first report, the progress report, the final report. But what do we actually do if an employer is giving his own report and saying it's fine, but there's a worker with pins in the hand and cannot use the hand at all? So that type of understanding around not non-compliance as in the person didn't report, but the non-compliance of the process is there. What do we do when someone just doesn't register or does follow the process but gives their own reports, doesn't give the truth, or comes and says, no, they didn't fall from the ladder, we found them on the side of the road? Because I think that will bring us closer to the substantive change for domestic workers, because I think that's the gap. There's the law and the process, but then you have the domestic worker saying, but my employer is actually not doing any of that. What do I do? So that's the question I think I want to leave for you guys, if you can think about that. And even if there isn't a provision, then that's good for us to know as well, because then that means we must think in terms of collaboration, in terms of reform, how we ensure that change. But then I think as we're shifting gears, because we, spent, I think, this first hour on what is the context, what is the law, where we are. And I think what you both have done now is kind of shift us into this lived reality change. A big thing coming up from the lived realities for the domestic workers is violence in the workplace. It's that intersection between violence and harassment within the world of work and how that violence gives rise to injuries on duty. And so I wonder if the colleagues from CIRI can just give us a legal opinion on whether violence, sexual harassment as it occurs in the workplace, does that, because Spinky was talking about how, for example, they assist with CCMA complaints and all of those things. But that's the labor recourse, that's the labor rights protection. In terms of the social security, would I have recourse in terms of COIDA for that violence that is due to and out of the scope of my work and provides me with an injury? And I think that's a very unique thing to ask, because I know that the amendments, for example, the COIDA amendments speak to psychosocial. It wasn't there in COIDA, and the amendments now speak to psychosocial, I don't know the wording goes for me now, but it's a sense of psychosocial support and compensation that can now also be provided. So, for example, if I experience sexual harassment in the workplace, and then the psychological effects of that as well in and out of the scope of my workplace, just in terms of understanding legally where that takes us. And I know that those are two heavy questions, and I can see us all take a little bit of a dip. So I want to just ask and maybe give, thank you so much, Kelly Ann, for your question, because it really took us nice into the substantive second half of the session before we end for the day. But I want to maybe just give everyone like a bathroom break, if that will help. But if we can be really quick, it's 11:33 now, so can we take 7 minutes, quick bathroom, or grab a cup of coffee if there's still some coffee up there, just to pick up our sugar levels, and then we come back at 20 to 12, please, just to finish that, and it gives our colleagues a little bit of time just to think about those questions. And then to everyone online, we'll be back in 7 minutes at 20 to 12. Thank you so much. we just needed a little bit more of sugar to get us through the rest of the session. So I think we're going to come straight into where we left off before we ended. And I think it takes us into kind of the building and solution part of the session for this morning. I think if we can start off with our colleagues from SERI just giving us an overview. I know our colleagues from the department said, there isn't a special category for domestic workers. They don't have specific claims or processes. It is the same process, and it's the same, the benefits and the categorization of the benefits and that. But I think what we've learned from the unions and from the Employers Association is that it is a very unique sector. And so injuries arise in a unique manner within the context, within the household. And then in terms of the COIDA amendments, when we look at psychological, compensation as well, how do we measure injuries in and out of the scope of the workplace, in particular when they come from violence or harassment within the workplace? And if you can give us an overview of that, and then we'll go to the fund around the issues of non-compliance, around the issues of not non-compliance necessarily in terms of the section, but non-compliance in terms of I've been harassed, or I've been abused, or there was violence and I sustained these injuries, or I sustained it because I fell off a ladder or whatever, but my employer doesn't follow the right processes, doesn't fill out the right complaints forms, or lies on those forms. And so if we can start with that, please.
Thank you so much, Program Director. I think that the onset is the understanding that the purpose of COIDA, or the objective of the Act, is to compensate for injuries that were contracted at work and for diseases and viruses that you contract in the course of your employment or in the course of your work. So taking it from that point of departure, we ought to then understand that if there is legislation or an administrative process in place where there is a provision of compensation for injury, then we need to look at injury as in the way that it is presented. It is quite common that when we speak about COIDA, we speak about someone who goes to work, they sleep on a step ladder and they fall, and that there is an injury that we must look at and there must be compensation for that injury. But it is also obvious that injuries come in different forms. An incident could occur at work that causes psychiatric injury. An incident could occur at work that causes traumatic injury. And we must take that understanding that COIDA is recourse for injuries and diseases that are contracted in the course of your employment or in the course of your work. So COIDA ought to provide compensation for these kind of injuries. People who suffer sexual assault are not only victims of the sexual assault, but they become lifetime victims of the trauma that is caused by that sexual assault. And if you suffer that kind of trauma, evidently you will not be able to perform your work the same way you used to before that traumatic event occurred. So then the balance is therefore struck between the medical expert report provided by the medical officer that that particular worker consults, that and a reconciliation between what the medical officer of the fund will say. And I'm highlighting this purposefully because there's always a contradiction when it comes to the compensation or the quantum of the compensation whenever there is a claim before COIDA, or before the compensation fund rather. And the contradiction is always whether the assessment of the doctor, of the private doctor, and the assessment of the compensation fund doctor can allow the parties to reach a mutual conclusion about the veracity of the injuries or the disease and the quantum of those damages. And I'm going to highlight an example of a matter that we have. We have a client that, Mangubane. Mangubane was a domestic worker, a cleaner, who got injured at work. And as a result of her injuries, she went and consulted a medical practitioner who declared her to be suffering from some disablement. But now the contradiction became on the question of the extent of the disablement. But the bottom line is that there is disablement caused by the injury. When a claim was lodged and the compensation fund was paying the claim, the quantum of the claim or the payout was so minimal that client felt like her experience on a day-to-day basis as a result of the injuries do not make sense in light of the payment. Maybe I'm not being clear. The person who understands the extent of the injuries is the victim. And the person who understands the extent of the disablement is the victim. And in line with the victim's account, she is clear that she doesn't think she will be able to perform the work she was doing again. But when you look at the payout from the compensation fund, for which maybe perhaps we need to understand that the compensation fund is not doing a favor to domestic workers. They are coming in to secure socio-economic security that they can no longer provide for themselves. So if it is clear from medical assessments that this particular worker, this particular domestic worker can no longer perform the duties of a domestic worker, whether entirely or efficiently as she used to before the injuries, at least the payout should complement the fact that you will no longer be able to provide socio-economic security for yourself. And we do understand that the compensation fund is not rough and should not be expected to provide the extent of compensation when we compare it with the other institutions. But at least there must be understanding that there is socio-economic security that we are trying to secure. And especially in instances where someone will no longer be able to perform their work to the extent that they used to before the injury or the disease. So perhaps I hope I answered the question of different forms of injuries, mental injuries, psychological injuries, emanating from incidents from domestic work. Because at least on principle, we all agree that there ought to be compensation for injury. The nature of the injury is a different conversation entirely. But before I go, I hand it back to you, Program Director. I just want to highlight that there is another issue we need to look at when it comes to domestic work. And it's an issue that has a lot to do with the historical context of our country. We are a transitional country. Even 30 years into it, instances like the exclusion of domestic workers from COIDA shows that we are still transitioning into a fully developed and fully mature democracy. But in doing so, we ought to go back and understand the relationship between an employer, a domestic worker employer, and a domestic worker employee, at least in the context of our history. Because when you look at it in that way, you understand that there is a very racialized understanding of this relationship. The employer, which is usually and in most occasions white, and the employee on the other side, which is usually on most occasions a black woman, there is very little recognition of the humanity in the employee. And this has a lot to do with the historical context of how domestic workers were treated during the previous regime. And we ought to defeat that legacy if we want to recognize domestic workers as workers in a democratic society. And you understand and you see clearly that there's still traces of the previous regime in the relationship between the employee and the employer. You see this through all of these incidents. I was thinking would attest to this. All of the incidents that we see arising between these two individuals and their relationship. In most occasions, we have to deal with the most gruesome of incidents. Sispingi just highlighted an incident where a domestic worker was attacked by the employer's pit bulls. There's many of those incidents. We have a case where a domestic worker was called from the inside the house to come and open a gate because the electric motor had suddenly failed because of load shedding or whatever the reason was. And you understand that this is entirely removed from the duties of a domestic worker. But the employer can simply just shout the name of the domestic worker to come out of the house and come and open a gate. And while she was doing that, suddenly the gate motor started working again. And the gate crushed the domestic worker against the wall, causing her to instantly die on the scene. But when you look at the actual facts of the case, you realize that there is very little humanity in how these people treat each other. One, the employee doesn't see the employer as a human being. They see them as this very supernatural, extremist individual that they report to. The employer sees the employee as a subhuman entity that they can give any form of command to. And hear me out, this is not perhaps the entire picture of the relationship. There's instances where there is a very good relationship between the employee and the employer. But there's also these instances that negate that there is still a history of, or there is a legacy of the history of the previous regime, especially in the relationships between the two. Sispingi narrated a story to us about a domestic worker, rather a gardener, who was on that particular instance called to come and perform the duties of a domestic worker or a cleaner. Got injured in the process, and when they took that person to hospital, they were bold enough to get there and say, I found this person on the side of the road. So it shows the lack of humanity and respect in the relationship between the employer and the employee. And this, in my opinion, has a lot to do with the refusal of employers to voluntarily register their domestic workers for COIDA. And it's not only a question of COIDA, it's a question of the UIF as well and other benefits. But today the conversation is about COIDA. So we ought to look at that as part of our discussions. How perhaps our colleagues from the compensation fund could help us with the determination of the quantum of the payouts, especially in line of the objective to protect the right to social security. I will end it there, Program Taylor. Thank you so much. My colleague wants to add something there.
Thank you so much. Just adding to what my colleague has said, I just want to re-emphasize parts of the judgment in the Mahlangu case. The judgment was clear, still echoing Asenati here, in that this is COIDA is meant to be a social security. So that speaks to the lack of awareness to some extent to some of the people who hire domestic workers, that COIDA and how the payment gets to be paid, it's not a fault-based system. It's not like in delict where you have to now establish a factual fault, that the employers are going to be the one who are paying the compensation. It does not work like that. So hence then you would find cases where the employers use their own doctors, coerce the doctors to provide doctors' report that aren't factually true. This is because of maybe that lack of understanding that it's them who are going to pay. This is meant to be a social security that all domestic workers are entitled to under the South African law. Another thing that I wanted to say was domestic workers are a touchstone of the modern democratic idea. So what that means is that if you want to see whether the Constitution whether the laws, whether legislation work, you're going to test them with the domestic workers. If you want to see that they are progressive, if you want to see that we are making progress, then you got to test them with the domestic workers. So if today we are nearly 5 years after the judgment, however, we have less than 30 cases that have been processed, that is an indication in itself. So the compensation fund must be alive to the lived reality of the South African people and its history, especially if you're going to take into account the issue of retrospective claims. To what does that actually mean? So now it's an issue of striking a healthy balance between the bureaucracy of it, of COIDA. What are the documents needed? What proof needs to be submitted? And justice. So if you're going to have a case that happened as back as maybe 2000, not even in the 1994, but just 2000 or 2005 or 2012, where you don't find a doctor, what does the bureaucracy say? What does the system say? The domestic workers being sent pillar to post, the inaccessibilities of the labor centers. So that is a very, very much frustrating system for domestic workers. And it's domestic workers which are living different realities. You have domestic workers from South Africa with papers. We have migrant domestic workers, which Mamege raised here. What happened to such cases? Because we do know that there are migrant domestic workers. We also know it in our history that we had migrant minors, and they also lived a different reality. So that protection is not afforded, to such domestic workers. So what I'm calling for is a serious look into how the system works in terms of COIDA claiming and trying to strike that balance between justice and the bureaucracy, so that domestic workers gets protected, they get the recognition that they deserved, that they are workers. Even the domestic workers themselves, they claim this name, that it's work. They are workers. It's not aunties. Yes, you can call them aunties. However, at the end of the day, they are workers. In terms of now of the professionalization of or formalization of domestic work, I say it should be formalized. How that will look, I don't know. However, if we start at the point that this is work, that is worth of respect, then there needs to be rules, there needs to be regulations that needs to be followed, so that everyone gets to benefit gets to benefit through the laws that are in place, through the laws that are applicable to everyone. Last question on the issue of the sort of the sanction or punishment. I'm just interested in that to what does it actually mean. So I'm basically repeating the same questions to what happens in such cases. Thank you.
Thank you very much to our colleagues from SERI. I'm going to, because I think there's so much that came out from your contributions, very rich contributions. It already took my mind to some of like our concluding discussions around innovations and initiatives and collaboration. So I'm already going to way forward. But before we get there, I just wanted to maybe reframe, because I think in light of what we got from the unions in terms of lived reality earlier, and then the very rich insights by our colleagues from SERI, I think just to maybe help isolate the incidents or the discussion points for our colleagues from the fund, I think the first issue that comes through clearly is this issue of quantum and how we understand quantum and how that reflects to domestic workers' lived reality. There's the issue of accountability. So if an employer doesn't register the employee, there's non-compliance, but also where, for example, they bring their own documents or documents that doesn't reflect the injuries. And then the last issue that came out about accountability for employers. And I want to add to my colleague from SERI and his question about accountability from employers, because I think, I don't know, Spinky, if I had gotten this from you one time, but there's a question that came up when we were doing work with domestic workers around, when you look through the amendments, they talk about non-compliance and they talk about, and I think you mentioned it earlier about how an employer can be fined. But it once again brings about this gap in lived reality, because even if the employer is being held accountable through the fine, still what happens to the domestic worker who maybe wasn't registered, wasn't paid? So there's that discord between the social security kind of process, rules and accountability in terms of employers. But then even if we're holding the employer accountable through a fine, I still don't get the compensation. So I think those are the three things around the quantum and what domestic workers actually get paid, accountability and non-compliance, but then that gap around accountability versus protection for the domestic worker.
Okay, on the issue of the quantum, I think my colleague is going to elaborate on that part. On the issue, when the employer did not register with the compensation fund, and it happens that the employee get involved in the accident, the compensation fund, and the employee reports the matter to the compensation fund, and the matter is being reported to the compensation fund, even though the employer was not complying, the compensation fund will compensate the employee, even though the employer was not registered. We will assist the employee, as he mentioned that we are a social justice system. And indeed, any person needs to be protected by the Constitution. But we will deal with the employer who did not comply and register. In our Principal Act currently, the employers who are not complying, they are found guilty. They should be found guilty for non-complying. But in the amended act, they're going to be liable for a fine. So the Principal Act is being guilty of violation the act. The current, the section 89, to report the matter and also to comply with all the requirements from the COIDA. But in the amended one, they will be indeed liable with the fine. So we will definitely assist the employer who is injured, and then we'll deal with the employee who's injured, and we'll deal with the employer. In a case where the employer send the employee to his doctor and maybe they cook the documents, they don't give the right information. As I've mentioned earlier, I've mentioned that when we make a decision, we make the decision based on the document that have been submitted to us. And then we will state our decision on the decision letter, which is an award. But now, once it comes to the attention of the employee, that indeed they've made a decision, but I don't agree with the decision based with this medical report that was submitted to the fund. Section 91 states clearly that of the COIDA that indeed the employee has a right to file an objection. In other words, to dispute the decision that was made, and he can refer to that. I do not agree with the decision that was taken based on the final medical report that was submitted by Dr. So and so, because my condition is still worsened. So now the matter will be referred to the legal officer who will review the matter. He will review the objection. Remember, the objection is more like an appeal. The person is giving reasons that why I don't agree with the decision that is taken by the fund. So we'll review that matter. The legal officer, he has a right to refer the matter for Section 42. Is further medical examination is there in our COIDA Act. If we are not sure, indeed, we can refer the employer. He must subject himself to the further medical examination under Section 42. In other words, the fund will pay for all the medical costs, will refer the employee to the specialist to be examined by that specialist. It can be the decision that is taken by the legal officer who is reviewing that objection. Or the legal officer can refer the matter back to medical claims or to claims to speak to the medical officer and discuss the matter, and then they can come to a different decision. Or if maybe he is still not convinced, he can refer the matter for a hearing. Remember, in Section 91, our hearing is heard by the independent tribunal. In that tribunal, most of the time, we have a medical assessor who's there to advise in those tribunals. Then in the tribunal, definitely they will make a different decision, and he can come and present his case and show the conduct, or maybe the, how can I put it the right way? The condition, his condition. Maybe what is on paper and what is in front of the tribunal, it will be different. And the medical assessor is there to assist. So there are remedies. In the Act, there are so many remedies that to assist the vulnerable employees. The Act is there to protect. And definitely we are trying by all means to protect the vulnerable employees. And since the Act has been amended, colleagues, we have done the imbizos and we are busy doing the publication of the, we are trying to do the presentation, province by province, of the code amendments presentation. And also, we did so many radio interviews. Even myself, I participated. I remember I was interviewed by Ikakasi FM. We explained exactly what the amendments in the COIDA Act and how does it affect the employees in different languages, including I was doing the vernacular one, the isiZulu. And we are trying to reach out to people that indeed the Act it has been amended. We are trying to rectify the history of the past, that you are now covered as employees. You are being recognized as employees, and we are willing to take your claims as back as 1994, April 2027. Thank you. Yes, I think I can proceed, my colleague.
Just the one other question, I think, was the issue of migrant status as well. So before you hand over, I don't know if you want to do it, but the issue was around domestic workers who don't, for example, have proper documentation before their employers. And if they do access a complaint and they get to the fund, and they have the issue of not having an ID document or a valid document, is there a consequence of that in terms of the complaint?
Okay, yes. At the end of the day, we will assist the employee, and then we will deal with the employer for not complying, because remember that one is in violation, including the Home Affairs laws and all those things. So definitely it will account. It will also need the other department sections and also the violation. That is a criminal on its own. But the issue is that if the employee he was injured, the fund has a responsibility to assist that employee. We have so many employees who've been assisted, especially in other cases, like there are fatal cases we need to support at the end of the day. Then the employer, he's the one who was guilty for employing and not demanding the proper documentations. So, but the issue is that let the vulnerable employee be assisted and also be taken care of, and then that is our duty.
Thank you. The issue of quantum payouts. This is how compensation fund functions. We determine benefits based on the salary at the time of the accident or at the time of the diagnosis of a disease. If, for an example, I'm amputated my left arm and my boss is also amputated the left arm as a result of an injury on duty, we are not going to get the same amount like with road accident fund, because his salary is higher than mine, my salary is less than his, and the benefits are calculated based on the salary at the time of the accident. But if they are very too low, we've got what we call minimum benefits and minimum salary and maximum salary. In other words, if my salary falls below the threshold of what is minimum, then they are going to use the minimum amount to determine my benefits. Similarly with a director who is also an employee, if he has declared so when he was registering for the return of earnings, there's a maximum amount of compensation that is a ceiling. You cannot cross it and get more than that. On the issue of psychosocial injury, where you have experience within a household, traumatic experience, you have a traumatic encounter. We call that, you can develop a disease called PTSD, post-traumatic stress disorder, and compensation fund is compensating for it. So people who are getting abuse within private household, if the doctor says the thing is so traumatic that the person has developed post-traumatic stress disorder, we're going to compensate for it. And then just to emphasize on the issue of medical documents that do not reflect reality, there are two ways of dealing with that. First of all, like my colleague indicated, the commissioner may seek a second opinion by way of Section 42 by referring the employee to medical evaluation in terms of Section 42. But secondly, in our tribunal, there is a medical assessor who can independently look at the reports and listen to the testimony of an employee and say, based on this testimony and based on this report, I am not happy that it reflects the true reality of what actually you are suffering from. Therefore, I'm also going to refer you for Section 42. So it can be done by the commissioner or by the tribunal, the referral. I think I've taken all the questions. Thank you.
Thank you so much. Before we conclude our session for the day, I know we were hoping to go to 12:30. Maybe we just do a few minutes more. Before we go into just concluding remarks and way forward, I just want to check if there's any questions on the chat online for any participants, if there's anything that we haven't covered or addressed. Are there any questions for the... Just the one from Kelly Ann. Okay, so there's no questions online. Our colleagues from SERI was talking about looking at a holistic approach when we're looking at Social Security and COIDA today. And it just made me think of some other instances, right, within the workplace. When we made submissions as an organization on the COIDA amendments, we had made examples of how I think the amendments, it spoke to how there's dependents. A dependent is someone who I think is up until 18, and if they are over the age of 18, I think it's up until 24 if they're in tertiary education. And one of the examples of lived reality we made in our submissions was saying how, and this links back to the context of domestic workers, we were saying how we have to take cognizance of the socioeconomic background, the racialized nature of the domestic work sector, because we were talking about, if you look at an African, and if you look at it through an African feminist lens, if you look at it through a gendered lens, if you look at it through an intersectional lens, right, what we see is that the domestic work sector is, I think statistics, and I think the global statistics show that 80% of the domestic work sector is women, so it's a highly feminized sector. And then if we break it down further than gender and we look at the race, it's also majority black women, right? And then we spoke about how within an African context, the dynamic of family looks very different for African communities, because I can have a niece who I've taken in with me and who grows up with me in my household, and I'm her primary caregiver, and she, for all intents purposes, is my dependent. And so too, in the case of Mahlangu, the daughter was actually unemployed and at home, while the mother was the primary caregiver as the grandmother to not only her daughter but also the grandchild who lived with him. And so in an African context, dependence looks very different because we have different family members which we take in for different reasons and who for all intents and purposes are our dependents. So we have an instance where the law was amended, included domestic workers, it included dependents. However, 80% of this specific sector would still not be protected because a dependent wouldn't classify. Because also if you look at the racialized and the socioeconomic background is for the domestic worker sector, given the minimum wage that we work for, not a lot of our family members are able to attend tertiary education. So even if there was a dependent who's over the age of 18 or under 24, we don't have the means for their tertiary education, and so they still wouldn't be able to qualify for that. And I raise this because I look at how we're all here and we're trying to think about what are the solutions, how do we bring the law closer to people, but that lived reality still shows the vulnerability and the gap. And then we look at this holistic approach, right? Because if we look at, for example, the code that speaks to sexual harassment, the handling of sexual harassment within the workplace, and we look at various other instances within our law, there's often aspects where, for example, the code would speak to how, if I report someone for sexual harassment in the workplace, I have the right not to be victimized or harassed, or I can't necessarily lose my employment because I've made the complaint. And I wonder if something like that exists in COIDA, or if there's scope for something like that within the COIDA provision, because I think you speak to, there's a lot of remedies that are available. So should the employer not register, should the doctor's forms not be there, technically on law, in terms of the amendments, as a domestic worker, I should be able to have those remedies where I can go and say, please investigate this, please review this, I object this decision because actually my hand was hurt, let's go through. But the vulnerability is that most likely I won't do that, because I know if I go and take that complaint further and I object, I'm going to lose my employment. Right? Even if it goes through the remedy process, which you've highlighted is available to me, I'll most likely be fired. I'll most likely won't have a place of employment. And for domestic workers who work in private homes, so many of them live there. So there's the intersection between my work and my accommodation. So I'm rather going to sit with a broken hand because I get to live where I'm working and I get that salary which I get to send home to my family, instead of going through this remedy process for non-compliance. And I wonder if there is scope, like within our other laws, that tries to protect vulnerable groups from when they make complaints against dismissal or unlawful evictions. I wonder if there's scope for that in COIDA, if it already exists there and we maybe just need to interpret it in this way for remedies, so to protect domestic workers when wanting to object to claims, or if it's not there, how we think about creatively, we try and test some of these principles in collaboration with domestic workers and look at it through that holistic lens. And with that being said, I want us maybe now, just as a way forward and some concluding remarks, I want to give everybody an opportunity who joined us here today to give some concluding remarks on things that may have popped up for you during the session, things that may really have stood out for you that you found either helpful in terms of information, things that you think would be really creative solutions or initiatives, because I think ultimately the purpose, as we stated at the outset of today, for the Women's Legal Center and the South African Human Rights Commission in collaboration was to make sure that any initiatives that we go through for this year is informed by the lived reality of all stakeholders, but most importantly, informed by the vulnerability of domestic workers within their workspace, within private homes. And so I want to start with giving, there's a hand online. Okay, so can we ask the hand, because I don't think we can unmute them, we won't have volume. So can we ask the hand online to please chat, send their question, comment, or concluding remark in the chat box, and then I can read it out loud with their name and their designation, please. And as we do that, I want to maybe first give Izwi and Udosa the opportunity just to reflect from the lived realities of domestic workers what I think would be the highlight or takeaway for you as we think about initiatives, collaboration, and solidarity. You know, we've heard the processes, we've heard the laws, but if we're going to, like our colleagues from SERI said, if we're going to have another year where we look at now 3 years post-Mahlangu or 4 years post-Mahlangu, we've seen there's a gap. That is, I think the main thing is clear for all of us today, for all stakeholders. There is a gap from the judgment. The statistic shows us there's only 20 complaints. And maybe just to clarify, that's complaints lodged or complaints received or complaints finalized. The 20 complaints from the fund, is it 20 complaints that are lodged, 20 complaints that, or 20 complaints that have been paid out? Like, what is the status of those 20 complaints?
I'm not exactly sure because I'm from legal services, but what I know is that we have received at least under 30 not objection, but claims, and some of which have been accepted, some of which are still under investigation.
Thank you so much. So the statistic shows us there's a gap. Mahlangu was a judgment which recognized the intersectionality of domestic workers. It was a constitutional court judgment, so the highest court in our country which recognized these intersecting human rights violations that domestic workers experience and the importance of using an intersectional lens to highlight these issues. It said that this exclusion from COIDA is unjustifiable. It cannot exist within our democratic society. And it was a beautiful victory and revelation for the domestic work sector in the acknowledgement and the recognition of their rights. That judgment at the outset, really contributes, I think what our colleagues from SERI also highlighted, the value of the domestic work sector in relation to our historical context in our economy to date. But there is a gap. The statistics show us the gap. Our input in the room today from employers, from the fund, from the legal aspects, and from the domestic workers shows us there's a big gap. And, we don't want to be here 10 years later having this same conversation, So as we move forward, and as the Women's Legal Center, as the Human Rights Commission, as SERI, as the Employees Association, as the fund itself thinks about its work this year going forward around domestic workers, what are some of the highlights you think that will really help the sector? And what are some of the creative initiatives or thoughts you may have had of collaboration and solidarity that you think would be useful to really make substantive change within the sector of work? So I'll hand over and we can go around the room and then we'll address the question online.
Professionalization of domestic workers can make a difference to domestic workers. If employers, even the Department of Labor, because there are also issues with the Department of Labor. A domestic worker in Mpumalanga called me. She was injured on duty. She went to Labor Department. They said to her, that's happening in Pretoria. Compensation fund is happening in Pretoria. A labor official in Mpumalanga doesn't know about COIDA. And he's telling the domestic worker that you can only get that in Pretoria. So more education. The Department of Labor must train or workshop officials to know about COIDA for it to work for domestic workers. And also employers as well. They need to get workshops. I don't know, because as unions, we have our meetings every month with domestic workers. Others, they even have meetings weekly. So I don't know the employers' organization, how do they do it. But I will also say the Department of Labor must also be on both sides of the employers and the employees, addressing the workshops and any way that the employers can get the information. Because, as I've said, people cannot do the same thing. All of them decide to do the same thing. There are some employers that if they can get the correct information, they can contribute to the compensation fund and register their domestic workers. So, and also it's better because it's something that they do annually. And we have few employers who have registered their domestic workers with the UIF who are not even deducting that 1% from the domestic workers. So it's possible for them to register domestic work with the right information and right mindset. So we need to work together because these kind of meetings are going to continue to happen. That's why I was saying, invite domestic workers. Department of Labor, if you call in Mbizo, call in Mbizo in Pretoria and say you want 200 domestic workers, I can give you 200 domestic workers. Because we are reaching a few number of domestic workers. Others are keeping that information to themselves. They don't share it. And we also as unions don't have resources to reach all domestic workers. We are trying to use the radio interviews that we get and TV interviews to speak about COIDA, to tell domestic workers about COIDA. But not everyone is getting that information. And also, a physical meeting can also help domestic workers because they will have a chance to ask questions where they don't understand. So please try the government to get more funding or to do more money and hold these workshops for both domestic workers and employers.
Okay, thank you. Udosa and Sasau, they are my elders. I'm not allowed to speak before them. So as long as they're here, I have to speak after they do. So yes, my concern is to the Department of Labor to try to educate employers and then to enforce them to comply, and then also to the employers' organization. I still have the question to them on, are they educating their clients to register their domestic workers, even to UIF, before they register them to COIDA? I think they have to be educated more about UIF, as there is 1% from the employer and the employee on UIF, and there is nothing from the employee when it comes to COIDA. Only the employer is supposed to pay something. And then the other thing, there's some other employers who are deducting the money from the employees but not contributing to the Department of Labor. And then the question is on Department of Labor, what are they doing on something like that? Because you only find out only if you are supposed to claim that you are not, you are registered, but you are not contributing anything. And then the other thing is on the Department of Labor side, I think they have to put their website to similar to domestic workers also, because right now, it only for the employers. It's a little bit difficult for domestic workers to go through their website. And then most of the times it's also difficult also to the employers, because there's some employers who are willing to comply, but just because of the Department of Labor website, they are not doing anything. So I think there's also supposed to do some small advert on some other public places to advert what are they doing, what are the procedures they're supposed to be followed by the employers. And then the other thing, I think, supposed to be easier for domestic workers to check online if they are registered or not. And then especially the migrant domestic workers, because they can't be able to check if they are registered or not. And then the other thing is the Department of Labor to push the domestic workers, employers, to provide the payslip, because that's the only thing you can see that you are registered under Department of Labor for COIDA and UIF. Without the payslip, you can't even know that I'm registered or not. Thank you. Oh, the other thing, the last thing, I just wanted to send the message to the employers' organization. Most of the times we do as union educate domestic workers, and then we still pushing and trying by all means to educate them. But the other thing, we even noticed that we are not doing anything because they can't pass the message to the employers. But only the employers' organization, they can pass the message to the employers. And then I think if we can have the debate, that can help a lot if we can have a debate with the employers and the employees on one room one day. Thank you.
Thank you so much, comrades. So my concluding remarks here, basically to say that domestic work and domestic workers are worthy of their respect, and they need to be protected under the laws that apply. And I do think that the victory of the Mahlangu judgment is key. However, I'm more interested in the material gains that they deserve, that all domestic workers get to be registered. So it's still a long way. There's still a lot of advocacy work that needs to be done, of which as SERI we are doing. I'm part of that, and working in collaboration with the domestic workers. So we do try to spread the message. However, there's still more that needs to be done. There's still more collaboration from the side of the Compensation Fund, Labor Department, Employers Union, and the domestic workers union. So there's a lot of room for collaboration. So yeah, I'm just looking forward to that, and maybe a discussion with the compensation fund, because we do engage with them in terms of the strategies. For example, you mentioned the radio interviews. So we as CERA are also doing that. However, we want to have more reach where we inform domestic workers of their rights. However, I definitely acknowledge that the employers themselves also need this type of knowledge, so that everyone gets to know what's going on. Everyone is better informed, so that we can realize the social security that the domestic workers deserve. Thank you.
Thank you, colleagues. I think from my side, I just want to stress the importance of advocacy, but not just advocacy, but collaborative advocacy. We need to form collaborations with every stakeholder that shows interest in domestic work in order for us to achieve and at least expand on the gains of the Mahlangu judgment. CERA has been working closely with domestic workers' unions, because we understand that nobody understands that domestic worker space better than the unions who work and interact on a daily basis with the domestic workers. But above and beyond the domestic worker unions, there's also various stakeholders that show a lot of interest in domestic work. The NGOs, the compensation fund, I like to treat them as a stakeholder themselves. Other mobilization groups, community organizations, churches, and the likes. Basically every space, whether it's social, religious, professional, any space that has domestic workers or has a stakeholder that shows interest in domestic workers. Those are the targets for collaboration. In order for us to expand on the gains of Mahlangu, we ought to communicate our messages efficiently. I was home in the Eastern Cape in December, and I was having a conversation with elderly family members, and some of them are domestic workers and cleaners in different domestic worker spaces. And you understand from their conversations and how they participate in the conversation that very few people understand that there is COIDA and they can benefit from COIDA. There is a general understanding from our people that if you are injured, whether it's at work or on the roads or in any space, then there should be some form of compensation. But the actual details about the compensation is still very, very less known. People understand that if you're at work and you get injured and you get a permanent or temporary disability or disablement, then you should be compensated. But the clarity on the exact form of compensation, the institution, why you are being compensated, how you get compensation, is still what in my opinion, I think the advocacy needs to address. We need to get to a point where people understand that there is COIDA at least. And whether you are a domestic worker, you are a gardener, you are a cleaner, you are basically, if you are a general worker, you ought to benefit from a scheme called COIDA. And this is how that scheme works. In advocacy planning meetings with the compensation fund, I've always stressed the importance of going to the grassroots, which is why I make examples like churches, like community radio stations, like every grassroots mobilization space where we find particularly elderly black women who are the dominant part of the population in domestic work. So we ought to reach those people, and we ought to put in the most effort in ensuring that we reach those people. But I do just want to emphasize and stress the importance of collaborative advocacy in ensuring that we protect and expand on the gains of the Mahlangu judgment. Thank you.
Thank you very much, sir. I want to thank all the stakeholders for their inputs today. I think it highlighted our challenges going forward on the one hand, but on the other hand also everyone's willingness to work together to solve the problems that's facing this sector. Unfortunately, in South Africa, it is quite often the experience of employers being made out to be the big bad wolf, and I do understand where that comes from. I do, however, feel that that might be a generalization to a great extent. I do not think all employers can be placed in one category, and I think it is extremely dependent on how employers are approached and what the theme of the message to them is. I want to answer on the questions that was posed to Nyasa and to myself. And yes, I can confirm that we make it, if not our top priority, one of our top priorities, to not just insist employers and fight for their rights, but to inform and educate them with the purpose of ensuring better workplaces, inclusive of all employees and employers. I want to agree with my colleague from SERI. I think the best way forward, how we get there will be determined on how many times we get together again and how willing we are to put effort into realizing this. But formalization of this sector, I do believe that would prove to be best for all stakeholders, for the employees and for the employers. When one wants to protect the rights and enforce the obligations and responsibilities on employers and on employees, there needs to be clear and concise rules. The procedures that need to be followed, should there be an injury on duty, should there be registration by inception of employment, all of that needs to be clear. It needs to be communicated to the employees and to the employers so that they can follow that with certainty. That is rule of law as well. We need certainty and clarity for all stakeholders to understand. I think it's very important for the unions when they educate the domestic workers on how to approach the employers and ask them, have you registered with COIDA? Because this and this, you're obligated by law to do so. The message and the format thereof should not be a threat. It should not be, if you have not, you will be held liable for a fine. This will be enforced. We have seen in the past that the moment that the nature of the communication gets confronting, it's not conducive to that relationship. And this employer employs someone in the most personal, closest to home space, their own home, possibly, closest to their physical space of being and to their children. So it's very important to remember the relationship and the nature thereof. So it should be a positive thing. The message should be, do you know that you are not personally liable for the expenses should I get injured on these premises? This is my workplace. Yes, it's your home, but this is my workplace as domestic worker. And I can get injured or contract a disease here. But there is something as the compensation fund, which means I will not be out of work and out of pocket, and you will not be out of pocket for these purposes. But on that point, then we have to focus on a working compensation fund, because if they do go out of pocket, being the employer that wants to take care of the employee that had an injury, and they claim back from the compensation fund and that never happens, we're going to have to address that issue as well. But I think if the message and the approach forward remains respectful, conducive, collaborative, and positive, then we can truly achieve something. But I do undertake that Nyasa as an employers organization, even though we have employees across all industries, all sectors, will never abscond from the responsibility of ensuring that the employers of domestic workers know what their responsibilities are, and we will even assist them in complying with all of the legislation that applies to them. Thank you, everyone, for the opportunity today.
Thank you so much. Before I hand over to you, 1 second for the department to do its concluding remarks, we did get one comment in. And just before we end, or I conclude, I just wondered if I could please throw in the comment before your conclusion. Because I think it's actually I think this is a conversation, a whole conversation on its own that we can have discussed somewhere else. But it actually is the first time it's came up today, and it's from Ayanda Dlamini, who is from Show Me Your Number on online radio. And her question, or his question, is about, does the compensation for occupational injuries adequately address the employment arrangements of domestic workers for those particularly who are engaged through services like BARC, it's not in here, but like BARC services, in instances where domestic workers are injured on duty, who bears the responsibility? So I think the question is speaking to online services and the procurement of the domestic work services. So for example, like Sweep South, like other online platforms where as a domestic worker, I may be recruited to work in someone's home, not through the employer directly. I'm employed through the online service. So I go there for one day this week and I may never go back there again, or I go twice a month. But it's, it's through the online platform, and it's almost like a labor broker relationship where someone else is the intermediary. Am I still protected in that instance? And I'm so sorry to add the question in last minute, but it's definitely a conversation that I think should and can be held separately with domestic workers who work through online platforms. But if you can just give us a quick question to, does that person also qualify for COIDA? And if not, then it's a conversation we can take to another platform. And then your concluding remarks, please.
Thank you. Thank you. The short of it is that they are covered. The definition of employee includes, among other things, a person provided by a labor broker against payment to a client for rendering service or performance of work, and for which service or work such person is paid by the labor broker. So they are covered. Thank you.
Thank you. Any concluding remarks?
Yes. If one wants a change, the change begins with me. The question is, am I registered as an employer? Are we registered as employer here today? We want changes. Are we registered today as employers of the domestic workers? Let us comply ourselves first. Let us do by all means that, let us comply, colleagues. And the compensation fund is doing everything in their powers to reach out to people. Even there was an advert on TV about the domestic worker. But let us continue to preach. We can go far. We can go far and make other discussions. Let us explain to the people. Yes, it will do the radio interviews and everything, but we are the people, we are the foot soldiers, we are on the ground. We are in this together. Definitely so much, if UIF managed to make such a difference, indeed with COIDA we are going to win this fight. The way we are the spirit today that I've experienced is very beautiful. Different entities coming together, the stakeholders, with one purpose to find a solution. And there were more solutions than critics. In fact, I'm so inspired every day. Whatever that you've mentioned, colleagues, we take it by heart and we are going to work on it. Yes, we got our own weaknesses, but we're in this together. And the unions, all unions, I'm talking about employers, including the employees' unions, you are the people, we are the forefront. And we rely on you. You get information from you, such cases you bring to us. We take it by heart and we're going to assist each other. We will find a solution. There will be improvements. We are in this together. We care. We want to make it different. But the change starts with me. I want to make a change. I want to see changes. Definitely it starts with me to register as an employer. Let us all comply. Thank you so much.
Thank you again. We really appreciate the fact that we have been invited to engagement like this one. It's really an eye-opener to us. We have noted all the issues that were raised during the engagement, and we are going to report back to the Commissioner that we are not alone in this thing. We've got people out there and organizations out there, employer, organized business, SERI, and others who are in support of what we are doing. And we hope to see that the numbers will increase as a result of the advocacy. To use the precise expression that comes from SERI, collaborative advocacy like this one And then we hope to see the number of the employer registering their employees, and we also hope, I am taking medication, so it's really wreaking havoc in my brain. And also we hope to see the numbers of the claims being brought to the fund increase. I thank you.
Thank you so much, everybody. I'm really inspired by today's conversation. There were huge takeaways from today. I'm going to call in Zama back to the room to just conclude and just to send us all off on our way for the day. But I wanted to almost bring before us some tangible solutions that came out from the discussion today. I want to leave it with all of us, and then as the Women's Legal Center and the Human Rights Commission in partnership on relation to the domestic work issues, I wonder if there's opportunity for us to come together again. And like we do 3 years post Mashlangu, we look at 6 months post this meeting or a year post this meeting. In terms of our interaction, what gains have we actually made and can we measure it? Because the 4 or 5 takeaways from this that I just want to put out is the first point of collaboration. Everybody in the room spoke about how they're doing advocacy, education, and training. Every single organization. And I wondered what it would look like if we actually used each other in that advocacy and education and training. Because for the domestic workers, the issue is sensitization of department officials. Because department officials say, you know, compensation is only in Pretoria. So, and then for the department, it's about training for employees. And then for the Employers Association, it's about training of employers. And everybody is so inspired because we had the different context today. And I wonder if that type of collaborative advocacy, I think that's a term we're going to coin for this meeting today, collaborative advocacy. But I wonder if that would be useful, right? Because it's the thing about us working in silos to a certain extent. We all are working on domestic worker issues, and we're all doing education and training. And I wonder if we cross-pollinate in that way, if we bring the different contexts together, how powerful could that education and training be? Because it then brings us the different perspectives. It brings us the sensitization, but also it takes out the frustration of, you know, constantly bringing domestic workers into a space where they constantly have to talk about their lived reality, because that brings about pain as well. You know, having to relive those stories, having to relive very personal and intimate stories. And so how do we have that sensitization from our context? And I think that's that first takeaway that we can definitely do is that collaborative advocacy and training. Something that came up to me as we spoke today, we spoke about laws, we spoke about implementation, we spoke about remedies. Then we spoke about the vulnerabilities of domestic workers and enforcing that. And I wondered, but we're living in the 20th century where everything is actually becoming very digitized, right? We're living in this digital era. And regardless of where you are, almost everyone has a cell phone. And these days, almost everyone has access to social media, even on their phone or like a WhatsApp platform. And I just thought about an innovative system of tracking, because the domestic workers were saying, how do I even check if I'm registered? How do I check if my employer did that, first of all? But how do I lodge the complaint? And I wondered about, you know, these days, it could be a simple app on a cell phone where either you can quickly compute and check your status, or would it be useful or innovative for a domestic worker to actually have an app link or something where they can actually report an incident within their home without the employer knowing it? I mean, there's issues of confidentiality still, but what is an easier way of having, for example, a labor inspector come into specific areas, and how can we be creative about guising that type of protections that we do? So some sort of innovative and digital technology kind of innovations we can think about there. And then the power and collective force of social media, and maybe the Human Rights Commission can continue to work with all of us as we bring together, because everybody spoke about statistics that they find within their specific organization. But we live once again in an era of global social media. We see it in other sectors, how we're able to hold organizations, government departments to account through social media. Today, we know about a crisis taking place in another country because of social media, and how social media actually brings around evidence that can be used in court cases, in international court cases. So the power of collective social media, we all use social media platforms, and we can share it in the link today, but we can also share it amongst ourselves. What are our organization's social media platforms, handles, that we can share information, amongst ourselves as well? And then lastly, this issue of grassroots organization, because it brings up the very important context of finding domestic workers where they are, whether it's in a rural context or an urban context, it looks and feels very differently. So once again, having all of these initiatives being informed by that lived reality of where domestic workers are. And we'll see with the Human Rights Commission about how we share information amongst ourselves, how we use that information usefully so that we can continue to be stakeholders that rely on each other as we move forward. Thank you very much.
Thank you so much to everyone. And this brings us to the end of our engagement. I was just outside manning the online system, and we saw how many people actually joined from outside to actually participate in this discussion, and how many people are actually interested in this discussion. Indeed, as Chrissy has said, that the Commission, looking at its strategic planning for the next year, wants to take this matter forward through our different mandates, which are our protection and our promotion mandate, but as well as our monitoring mandate. And where there are loops where maybe one institution says we actually can't access that place, that is where we need mapping and saying how do we access and how do we actually get onto those platforms. And one of the mechanisms that we use quite a lot are community radio stations, where we do our advocacy work, where we do our education work through those community radio stations, where people call in and ask all of the questions that were actually asked today. And looking at the questions that were asked, it seems that is quite a big information gap about what is currently happening and what is needed. One can think about, as said earlier on, that the relationship between an employer and an employee looks different in this context, because you're really in somebody's in a very, very personal space, seeing a lot of things that are happening in that workplace, in that home, raising those children, forming a family and forming a very intimate relationship. Now, in that formation of the relationship, one always has to make sure that the rights of each person are respected, but also the respective responsibilities that arise because of that relationship. And from what was undertaken today, we will reach out as the Commission again to say, based on what was agreed upon, and we hope that everybody around the table will also then be open to how do we make this information available, whether it is through an info sheet that we have that is printed out for everybody, that we have when we are also doing our respective outreach in the province, when we are doing our radio communication. If we're saying, listen, can Izwi join us when we are doing this interview for information sharing, etc. And we all just partner in terms of making sure that the information is really out there in our respective spaces. So on that note, colleagues and online as well, thank you so much for participating. Thank you so much for sharing your questions and insight. And should you, on the chat, because if you've joined online, you will be also able to access this link again. We will share the information of the respective organizations on the chat. But if not, please reach out to Bongiwe Gumede on bgumede@sahrc.org.za for any other information that you might need. And everybody who is here, thank you so much. Thank you so much to our sign language interpreters and to our crew for also assisting us today, and to our lovely, lovely venue. Thank you so much, everybody. Please travel safely, and online I would invite you to lunch, but that would be very awkward. So you can enjoy the lunch where you are, and to everybody inside, please also join us for lunch. Thank you so much.